Hey, welcome everybody to Spin Legal on Wednesday, the 28th of August, 2024, with me, Peter Giblett, and also with me is Angela Browne. Hi, Angela.
Hi, Peter. How you doing?
Good, and we're partners at Invictus Legal LLP. So tonight our topic is the common myths of employment law. So we're going to talk through some of those this week, and next week we're going to talk about some of your employment rights, some things you need to think about if you're fired from your job. So this one is a bit, this one we're doing this week's a bit lighthearted, but hey, lighthearted we take, right? Okay.
Yeah, lighthearted but educational.
Yeah. Okay, so if you need to contact Invictus Legal LLP, you can do so on 905-688-5598. Or you can email Angela at weareinvictus.legal or Peter at weareinvictus.legal. Our website is https://weareinvictus.legal, as you might have guessed. Okay.
Yeah.
So let's talk about some common myths of employment law. We've got 23 of them. I'm sure there's a lot more than these 23.
Oh, yeah. There's a lot of people who will come into the office and say, aren't I owed like a month for every year I worked? No.
Well, actually,
there's a lot of things we could talk about. There's a lot of common things that people think.
Okay, and as a point of education, what we're talking about here is for non-union workplaces. Now, in Canada, the vast majority of workplaces will be non-union. Although that said, the vast majority of workers work in union workplaces. Yep. So if you work in a union workplace, the rules are slightly different.
Yeah.
Okay.
Like at some point we may want to talk about that, but as I said, like if you're let go from your job, for example, that's handled differently in a union workplace than it is in a non-union.
Yeah, absolutely. Okay, so let's go to some starting ones. But before you start your job, okay, it's illegal for interviewers to ask questions about protected class status. And protected class status is sex, race, religion, etc., etc., etc. Yes?
Yeah. I mean, the thing is, it could lead you into hot water if these things are not asked in the correct way. Okay? And it has to also, if you're asking questions about something, it has to be very relevant to the job.
Yeah.
Okay?
Like, for example, if you're disabled, it might well be asking, how do you expect to be able to get into work for 8 o'clock every morning on a Monday to Friday basis?
Well, that you
might
can
be
ask
legal.
that. You can
That
ask
might
that.
be legal, you know?
Yeah.
And that, so long as you ask that for every single person that you're asking the question.
As long as you're asking it of everybody.
Yep.
And if there's a question, sometimes you might say, do you have any kind of issues with respect that without a combination, you would not be able to do your job?
Yeah.
Okay? So say, for instance, if you're legally blind, you can do your job with a combination, a screenwriter or something like that could help you with your job. Okay?
Or you
So
can
there's a lot of things that they could ask you, but you have to know that with the combinations, I could work.
Yeah, yeah, absolutely. With things like blindness, again, I've met blind programmers in my life.
Yep.
They're very good at their job. They're very, very good at their job. Be very, very clear about that. Okay, so let's go on to number 2. My employee handbook is my contract. No. Why
Your
is that?
employment contract is different because it specifies your job, who you are, what your position is, what your hours are, what your rights are in terms of the hours per week, if there's any termination clauses, if there's things like that. Employee handbook basically kind of gives you an idea of the rules that the company has. Who do you talk to if you have a complaint? Who do you
And
go to?
actually, and the employee handbook is largely about practicalities. For example, I worked in a workplace one time whereby they said, in the case of fire, call 1111, right? And the idea was that they would actually have an on-site fire specialist who would ask you certain questions about the fire incident that you saw, and based upon that fire incident, may well then said, that's okay, we're going to send our guys around there to go sort the fire out,
Mhm.
right? And if they would come, they would be the only people that would call the fire brigade.
Yeah, yeah, because they just don't want to bring out like a 32 alarm fire station thing going
Yeah,
on by
yeah.
a workplace for
You
a
don't
school
want,
fire.
yeah, you don't want every fire engine in St. Catharines coming to your workshop because one cooker in the canteen burst into flames.
Yep,
That can be sorted out by
exactly.
the local guy who can, the local on-site fire
Yep.
specialist, right? Yeah, so that's what your employee handbook is there to tell you
Yep.
policy, your
Yeah, they'll also
contract.
outline your benefits,
Yeah,
okay, and and how to claim the benefits and so forth. And they'll talk about your vacation time and
yeah.
versus how many years you've been there. Like sometimes they vary by the years and various things like that. So it kind of helps you do that.
And your contract actually may contain some of the same things that are in your employee handbook, but your contract is specific to you and your job, whereas your employee handbook is something that's given to pretty well everybody.
Yeah, everybody
Everybody
that's
who
there,
needs.
they'll talk
Yeah,
about who you go into, how you get paid.
yeah.
Hey, who do you have to turn in
Timesheets
your
too.
bank, yeah, the timesheets to, different things like that.
Yeah. Okay, so the next one I've got is employers need a good reason to fire you.
Employers don't need any reason. I can have you work for me for 20 years. You come in every day, there's no problems. But then one day I just wake up, I said, I have to get rid of Peter. Hey, Peter, you're fired. Yeah, I can do that if I'm willing to pay.
Yeah,
Good, but it's going to cost.
yeah,
Okay, because they don't even have to have a reason.
yeah,
It could be a good reason, a bad reason. They don't have to. And it can be even worse if you fire someone for a reason that might be human rights related, or if there was some kind of retaliation, like say if somebody reported the employer to employer standard branch or it's starting a human rights case or something like that, which could be an issue.
yeah, yeah. Okay. And there's a lot of reason, employers can find almost any reason to fire you. Hey, you've got brown hair. I don't like people with brown hair. Hey, I've
I
got
like
to
my
have.
blonde, blue-eyed
I
people.
only want people with grey hair in my firm. I'm going to fire every. No, but in fact, that would be discriminatory. Whereas if I didn't say the reason, but I fired every person with brown hair, I could do that.
Yeah, yeah.
Yeah.
Because the thing is, there's nothing in the Human Rights Code that just says your discrimination on the basis of hair color.
Yeah. Exactly.
Yeah,
Okay.
yeah.
So next one we've got in this list is a probationary period allows employers to fire you at any time without compensation.
And that is also untrue. You could be working for 5 days for a company and then they can let you go. Maybe the Employment Standards Act doesn't have compensation available to you, but there could be a claim under common law.
Yeah.
Maybe they fired you for human rights reasons. Maybe they did for retaliation or some other reason that could be
Yeah.
identified.
It's like, hey, you sound like you're Italian. I'm firing you.
Yeah, there
Type.
was a gentleman who worked at a workplace for 8 days, and then they decided that because he was bipolar, that he was a threat to himself and he couldn't handle stress, so they fired him. And then he went and got $85,000 from the employer in damages. So employers have to be really careful about that one, about terminating people in a probationary period.
Okay. And the next one's an interesting one. Your employer can change your job description at any time.
Yeah, they can't. You're working, same as you start your job. Like say if you didn't have your job, you start your job, you didn't have a contract, and then 6 months into your job, your employer shows up and says, "Oh, sign this contract." Too late. Hey, you have to have a job
That is,
offer for your
yeah.
contract if you're going to have a contract, and if they're going to be changing your job description significantly, where there are some significant change of responsibilities or your pay, that there has to be some notice given.
And in fact, actually, this is a key fact that needs to remember that any contract you ever sign or agree to, terms and conditions are all negotiable up front. Once you enter into the contract, you're not permitted to change the terms and conditions
See, like this is
without.
what happened during COVID.
Yep.
When your employers were told to send everybody home, hey, for some companies that were able to do that. And then afterwards, everybody really liked it. They said, "Oh, I want to stay home." But the employers would say, "Well, COVID's over. We're coming back to work."
Yep.
But this has to be handled properly. Okay? You can't just tell people and promise that they can work at home forever and then all of a sudden say, want everybody back to the office. You can't do that.
Well, and the other thing about that is, prior to COVID, of course, some people, we know of some people who had contracts that allowed them to work at home, so they were working at home, and then post COVID, they were required to go get a COVID. They were required to go get a a shot
Vaccine.
vaccine. That's the word I was
Oh,
looking for.
yeah. We had people who were working from home and they were told that everybody
They-
has to get a vaccine or else you're going to get fired.
Yeah. So
Can't do that.
when you were working from home already and you were told you had to get a vaccine, otherwise you'd be fired, that's
Yeah.
wrong.
Yeah,
Yeah,
it has
that's
to evaluate your risk, your exposure to the public, a number of things that during the pandemic where they were able to whether this was mandatory or not.
okay. So
And in terms of
in
other
terms
aspects
of,
of your job description, they can't just change it overnight. They can't take responsibilities
yeah,
away or add them suddenly,
yeah,
without adding extra pay. They have to work on that and they have to give extra notice. And as an employee, if this is done to you, okay, if you start working in this new change job description for a specific period of time and afterwards, this could be a problem because it could look like you're condoning or accepting the changes. So you have to be very careful about that. So that's why you have to act quickly if a change is being threatened on your workplace.
and one other thing to note with this is that promotion brings along with it a new job description, because you were you were the person who swept up the lunchroom. That was your job title, lunchroom sweeper. Now you become managing lunchroom sweeper. Now you've got promoted. Now you've got a new job description. You negotiate new salaries, new terms and conditions, etc., etc. So
So you're
that,
overseeing the sweeping of the whole building now.
yeah.
So this gives you a new job description and better pay, hopefully.
Yeah, well, exactly. Yeah. Okay, and that's the whole point about promotions are, the job description changes, and as you get promoted, you get new descriptions come along. But
Yeah,
that's
because usually the constructive dismissal cases, I know when they do change job descriptions, it usually involves a demotion or a sudden commute that you didn't have before,
yeah.
or other issues that get added or benefits are removed,
Well,
bonuses
that
removed.
actually that actually brings to mind that, in fact, that's actually one of the advantages. That, for example, if you're doing your job and you work down the road in St. Catharines, and now your employer says, no, you've got exactly the same job, exactly the same salary, but now you're in Burlington.
Yep, exactly. There is more of a commute, and that could be argued for some people. It could be a constructive termination.
Yeah.
So that's something you
Exactly.
need to look for.
Especially if what you were doing is you were coming into work in St. Catharines every day and you came by bus. You've given up your car, you've not got a car because you're on the bus route. Hey, I can get the number 52 and it takes me, 14 and a half
Right to my
minutes.
front, yeah, 14 and a half minutes. It takes me right to the front door of my workplace.
Yep. And I get out and it takes me 18 and a half minutes to get home, plus 10 minutes waiting for the bus because it never comes to the bus stop outside work on time. So I've got to be there 10 minutes early because it's always late going home, right?
But
So
then
it
all of a sudden they
takes,
tell you that your
yeah,
workplace is going to move to Oshawa or something like that.
yeah. And
And
that's a
this
significant
changes things for
difference.
you.
Yeah.
And this is one of the things. So this is one thing to watch for if there's some significant change.
Yeah.
Right?
Okay. So remember, everybody, we're talking about common myths of employment law right today. And the next one here that we've got is salaried workers cannot have their pay docked.
Well, yeah, that's true. Like they can have their pay docked in the same way anybody else can, but then again, pay docked has to do with what's legal to deduct. And you generally, when you start working in Ontario, your employer is only allowed to take off union dues, CPP, pension plan benefits, benefit payments, that sort of thing. And they can't be taking off things like, say, you're working in a restaurant and then you broke a few dishes, and then the employer says, "Oh, I'm going to have to take that off your salary." They can't do that.
Well, the other thing about that is that I'm drawing a blank. Yeah. Okay. So, of course, one of the things that will happen in union workplaces is that you will get like union fees deducted, won't
Yeah,
you? Oh,
union.
the other
Yeah,
one
you
that I
have to
was
sign for union
yeah,
dues, and
and
there's a
the other
certain
one,
amount you pay every month, and it just goes to the union.
of course, is that you all workers, including salary workers, can be garnished if you owe a debt somewhere.
Yeah, exactly. The old child support, too bad.
Yeah,
Right?
exactly.
Somebody would garnish your pay, and whether you're salaried, hourly, or whatever, the source of income coming to you could be garnished.
Okay, another one is people who are salaried cannot get overtime pay.
And this is something that is very little understood. I actually won a case like this a while back where a salaried individual, but normally he was hired at about anywhere between 35 to 40 hours a week. And then all of a sudden things got busy and they decided instead of hiring another employee, they would just burn out the ones they have.
Well, that was an
And
interesting.
then he was working an extra 10, 15 hours a week.
Yeah,
And it got to a point where I was getting burnout, but there was no extra time paid. There was no overtime paid.
yeah, and there was an individual that I knew who actually he worked like 8 a.m. till typically 6 p.m. And often what would happen, he's salaried, and often what would happen is, oh, the computer would break down at so the computer would go offline at 6 p.m. all of a sudden, and everybody's in an emergency, and he's then online fixing the system. He's probably at home by 6 p.m. and he's online fixing the system till 2 o'clock in the morning. And
Mhm.
then, of course, he says, hey, I think everything's going. I'm going to bed now. And then at 5 o'clock in the morning, there's a phone call on his phone, and he's doing more fixes to the system. And then he's expected to be in at 8 o'clock in the morning.
Yeah, the sole IT person. Oh my God. Yep, yep. They have to pay it, and it has to be equivocating with respect to
Well, there's
being
also
prorated.
actually he has rights to take time off there as well.
Absolutely, and that's another agreement that sometimes we do, where you can actually apply. We've had work where I've worked with nonprofits and where we've actually set policies where if a person had to work some overtime and then the next day they would take some time off. so they
Yeah.
could work relatively similar hours each week and give them that type of flexibility, which worked for a lot of the employees because at that time the particular nonprofit I was developing policies for couldn't afford to keep paying overtime.
Yeah.
And so you
Okay.
really have to be careful, and you have to have everything put in by agreement. And when you do the loo time, it's not where you have hour for hour. It's for every hour overtime, it's an hour and a half, for the time off.
Right. So next one on this list is I'm due an automatic promotion.
Oh, and who does that sound
I've
like?
been working here for 15 years. I will become automatically promoted. No, you won't.
Nope, nope. There's nobody owes you a promotion. Okay, like if you're sick of doing the same job over and over again with the same pay, as inflation goes up and up and up and up, and now you're close to minimum wage after you started well above. Hey,
Yeah.
maybe it's time to
The,
find another
the
job.
average rate of pay comes down and the minimum wage just stays where it is, right?
Yeah. So basically, like you not do a promotion, but in general, in most workplaces, they try to find talent and they try to find a way for people to go up the ladder and then introduce new people to your old job, which is generally what most companies do, but it's not an entitlement. But it is something that companies do as a habit to want to keep people. So if they feel that you're very talented, say in the marketing department, and then they can move you up to become maybe marketing manager or some kind of thing. So I mean, these are things that
Trouble is with that is that three people started the same time as you. They can't all become marketing manager.
no, no, you have to find some other way of working with them.
Yeah.
So maybe yeah. So this is like it makes it hard for if you're going into a human resource type of thing, or if your company was fast growing at the beginning and you joined at the time the company was growing. So this is always makes it difficult for a company, but this is not automatically due, and it's not put into your entitlements.
Okay. The next one, I think this is one for you to read.
Oh, I'm a white male and cannot claim that I'm discriminated against. Well,
Oh,
they
you
have to be. Well,
can.
they're Brit too. Got to remember if they're Brit. Okay, okay, because British white males, no, you can't discriminate against them. Like it's like you could legally discriminate against them. Yeah, yeah, you can't discriminate against anybody, really. Okay, and the thing is, could they take action? Well, it depends on the type of action they have to take. Like if it affects dignity and encourages stereotyping or encourages some kind of thing like that, it might produce a litigible claim. But but you can't be saying I'm just going to be hiring only people of color in my workplace, and it's going to look odd, unless your workplace is set up in a way that you're working, like say you're the National Association of Colored People or whatever, hey, for helping them, right?
Uh, okay. Yeah, but again, even with those positions, there have been some questions about human rights and whether they can't employ people who aren't that particularly in that particular bracket.
Yeah, you have to be very, very careful if you're going to be exercising what we call an affirmative action workplace.
Yeah,
Okay? And it's not something that you can just say everybody must have this.
yeah,
You'd have to find out the best person who can do this particular job. Okay? So if you got two people who can do the job equally, one fits your group and one doesn't, you'll probably want to have the one that fits your group. Okay?
yeah,
But if two people can do the job, one can do the job really well and do very well for your company, and is not in your group, you probably want to take the other one.
yeah. Okay, next one. I'm a person of color and they can't fire me.
Oh, I've heard this before. Like I've had people say that certain people are racist, because and they just and they always say racist comments and they're afraid of being fired all the time. No. Like basically, people of color can get fired just like anybody who's white can get fired, just as anybody with disabilities can get fired. But you have to do it. If you intend to do it this way, you have to make sure that you're backing it up. You got documentation, you're corresponding with the individual, putting them on a performance improvement plan, making sure everything is cross the T's, dot the I's. Okay? And then, in
Again,
particular, if
again,
there's a reason that you're concerned about the person.
but again, 99% of all firings that are done in the corporate world today are without cause. So all I'm doing is like, hey, sorry, Abdul, we've got no more need for your particular position.
Mhm.
Bye bye, that type of thing.
And often, what they do in the corporate world is last hired, first fired.
There's that as
Regardless.
well.
Yeah.
There is that
So
as well.
so there's a lot of that, and they have to be a little careful of that too, particularly if they recently implemented an affirmative action program and brought on some people. Okay? And then they decide that, oh, we got to lay a whole slew of people off. you know.
Well, that would become problematic. That's
Yeah.
for sure.
So
When you
these are things that you
yeah.
have to look in terms of human resources, how you're going to do this and how you're going to work this out, because it becomes complicated when you have to address these things.
Yeah. And another one in the same vein, and can't be dismissed when on disability leave.
Yeah, generally, it's in the best interest of the employer to keep them on the payroll, or even though they're not getting anything from the payroll. But if there is a dispute and they decide that they're going to fire you when you're on disability leave, and the reason is tied to your disability leave or not returning to work because the employer decided you're able-bodied to return to work, but your doctor says you can't, and then you get dismissed as a result. Yes, that could be a nice big human rights suit. It'll be a payday. But however, if you're being there's going to be layoffs in your company and there's people who are on disability leave and that sort of thing, you could be laid off, and there could be
Yeah.
some implications
Um,
where that
then
and
the
that's no fault.
then the other one that's about this particular area, and I'm asking you because I'm curious about this one. So you're on disability leave, and you've been on disability leave for a few years now, and as you say, the employer is not paying you, but they are still on staff. Can they fire you when you become 65?
Generally, in some ways, they do, because your disability benefits generally run out at 65. So if you have an LTD benefit plan, they usually run out at 65. But what often happens is sometimes they'll negotiate the termination with people. And I'm talking government jobs. I'm talking about people who are lucky enough to be in a union, that sort of thing. Because this happened to a couple of people I know who became sick, and at a certain time they were starting to offer packages to people who are on disability leave who are on for beyond a certain number of years. So what they did with the packages at that time, anyways, I don't know if they do it anymore, but what they did is they may be just a certain amount of money that they would be paying into their pension plan to allow them to collect the full pension when they turn 65. But if they just left it as is, they would not have the full pension plan. So what they would do is they would offer to take part of the severance package, and they would pay that towards topping up the pension plan so that when they turn 65, they have a full pension, and then allowing them to live on long-term disability until they're 65. This often happens to people when they're about 50 years old or 55 or something like that. And if their disability looks like they're not going to recover, okay, so they would do that type of thing. And then by the time they turn 65, like the disability pension will continue to pay you. But by the time they turn 65, the disability plan is replaced by the pension from work and other pensions we get in Canada, like CPP and stuff like that.
Yeah. Okay. Where were we?
I can't be fired
Disability.
because I'm on disability leave.
Yeah. Okay. My thing's gone missing. Everything's gone missing. Okay, so to let everybody know, we're discussing common myths of employment law here on Spin Legal, and so the last one we just did was disability leave, which basically means it's illegal. The next one is it's illegal for an employer to read my emails, computer, and devices, etc.
And this is something that a lot of people believe. Okay? Actually, not true. The only thing that is true is that your employer has to tell you that there is no expectation of privacy when it comes to your email server, as long as it's your work server. Your employer doesn't have a right to go into your personal email or
Well,
your
again,
personal phone.
again though, if you access your Gmail on your work computer, the employer can see the information that is on the Gmail because it's going through work devices.
Yeah, and you have to be really careful. So if you are employed somewhere and are using your employer's computer, the best thing to do is leave your Gmail account at home.
Yeah.
Okay?
Or put your
Or on
Gmail,
or on your device or on your
yeah,
cell.
or use your Gmail account on your phone or
Yeah,
something like that.
because otherwise your employer can go in there, and especially if you're sending emails to different people and saying, "Oh, I can't stand my employer, especially my manager," that kind of thing, you know. And they say, "Oh, really? Maybe I
Yeah.
should print that out."
Yeah, exactly.
Yeah,
And that could be really bad for you if you're starting to mouth off about how bad it is working for John Smith and Company, you know?
yeah, exactly. So it's always best that if you don't, but they have a right to look into your work email, your computer itself, any kind of clouds you have, contributions to the cloud, any sorts of work that you do, all sorts of things, your timesheets, anything that's there, and they have a right to audit to show what you've worked on, and then you vis-a-vis your timesheets, things like that.
Yeah. Okay, so the next one on this list is the things I develop and the clients I find for my employer are mine when I leave.
Not so much. You're doing this, you're paid by your employer to do this work. And in some independent contracts, sometimes there is a contract, and the contract will dictate what's yours and what's the employer's. Okay, so you need to look at those things very carefully so that you understand what your obligations are when you leave. And the thing is, in general, you can't take what is the employer's when you go.
Is an interesting thing about this is that we were talking about this earlier on. One time, quite some time ago, when I was employed as a computer programmer, I left one place of work and I worked for another place that had the same software, etc., same same programming languages, etc. And when I got into the new job, they said, "Oh, can you write a program to do this?" And it's like, well, I know. So I kind of sat there for 5-10 minutes thinking about, well, I know how to deal with this. Did this before. I can take that. It's that program that I used back then. So I
Mhm.
sat down and thought about it, and then I just started clicking away, hammering the
Mm.
keyboard, and essentially wrote the same program as I'd used back there.
Yeah.
But the point being is I didn't copy it. I just
No, that's not
remembered it.
copying it. That's just writing it out. That's like if I work here and I'm doing statements of claim and so forth, and I leave here, then I go back there. I still have that skill with me to
Yeah.
be able to write the way that I do. Same as you. I mean, these are things that are not tangible or intellectual property. But what is intellectual property is that statement of claim you wrote for Jack Jones versus Smith.
Yeah.
Okay? You can't take that.
Yeah.
And or the clients can't take that. There's usually a period of time that they'll pass before you could, if you're out in the market, because like we were talking about that with another company, they wanted to upgrade their policies, and I said you have to be reasonable when you do this. Hey, like if somebody came in with something, they leave with that thing. If they developed it while they were there, while you paid them, they don't leave with it.
Yeah.
Okay? And if you even under some independent contracts, sometimes that's the case too, because you're paying for that skill
Yeah.
to be put into your company.
There was a time when I was writing a book about the type of work that I did. And I basically said to the person that I was doing it that I'm writing a book about this. I won't be using any specific examples from the company, but if you happen to have some examples that may well be relevant to the book, I might well ask your permission to do this. Right?
Mhm.
They were fine because they recognized that it was a work that I'd started before working for them, and I was a contractor anyway, and it was a work that I'd probably continue on after I'd finished working for them.
Absolutely, absolutely. Yeah, and this is like where you have people who are skilled. Like you might have somebody come to your workplace and say, "Hey, I like what Peter's doing." I said, "I was wondering if Peter would like to work for my company." Peter can go work for his company, but Peter can't take all the stuff that he did for my company.
Yeah.
Peter just takes his brains with him.
Okay. So this next one is a one that kind of is a big misnomer. And people need to pay attention to this one because ageism is becoming a big thing today. My employer can force me to retire. No, they cannot.
Nope, nope. In most cases, they cannot. There's
There's one or
some
two
areas
fields.
where there's some legislation where judges have to be retired at a certain time. And I think firefighters or something. There is a few of them like that.
Well, I would say there's a few jobs, like a judge, like a firefighter, where it might be appropriate to actually have either an annual test to show that they can do the job,
Mhm.
or once every 5 years or something like this. I'd even say that judge should not be forced to retire at 75. There could
Oh,
be
they
there
lived,
could
and
be a judge who's
Ruth Bader
90.
Ginsburg was what she was 94 when she died.
Yeah, she was 94 when she died. Whether you agree with her decisions is another matter, but she was cognizant of everything she wrote when she was 94. And again, a firefighter, yeah, might well be that you have difficulty climbing ladders if you're 78 or something. But again, if you pass the physical test, why not?
Yeah, I mean, this is the thing. And then what you can tell is that, say, particularly if you're in a workplace and you're approaching 65, or maybe you're just a little bit over 65, if you start hearing noises from your manager about, what is your retirement plans? Are you planning to retire? Like little things like that when they start talking about that. Eh? And if you don't plan on retiring, which many people are now not planning
Yeah.
on retiring, for many it's a financial necessity because like how many people got good retirement nest
Well,
eggs these days?
I was going to say the only way I could retire right now is to sell my house, move into an igloo, and you know, maybe I can retire at that point.
An igloo. Ooh.
Well,
Don't we have lots of them in Canada? Igloos,
it's the
Eskimos,
only
and
house that I could afford that
canoes.
costs $150 that gives me enough funds for retiring.
Yeah, yeah, yeah. Exactly. There's not many things I don't think I'll be able to retire.
Yeah.
Yeah,
Yeah. So essentially, no, you can't be forced to retire.
yeah.
Okay. So next one. My employer can stop me working for a competitor when I leave. Oh, no, they
This
can't.
is a big one because there's something when they stop the non-compete. There's something called the non-compete agreement. In certain circumstances, a non-compete agreement is legit. Like if your company has very specialized knowledge, does very specialized things, and then if you go to a competitor, it would be financially damaging for that your current employer. There could be some legitimacy with that. But if you're working at a Walmart and then you decide to go across town and work at a Winners or something like that, they can't stop you. Or even if you're a programmer and you're working at Microsoft and you want to move to Google or work at a startup, they can't stop you.
Yeah.
These are things that, as long as you're not taking stuff with you from your former employer.
Yeah. Yeah. And as I said, me thinking about that for a while and then sitting down and writing the code, copying my
Yeah,
recollection of what that code was
yeah,
is not stealing.
yeah, exactly. And this is what it is. It comes from your own basic knowledge,
Yeah.
okay? Because like that sort of thing. And then the thing is, what they do, it can like if you are taking things from your former employer, are taking like if you work for a law firm or you work for a medical firm or a dentistry firm or something, then you take half the staff with you when you leave. That's also could be litigible, so you have to be really careful too.
That's not the same as,
That's called the non-solicitation clause,
yeah,
as opposed
that's a
to a non-solicitation
non-solicitation.
clause.
Yes,
Yeah,
exactly. And
so
that's an entirely different
solicitation
matter.
is when you start stealing people or ideas, things, trademarks, copyrights, whatever,
Yeah.
work product.
And in a way, if we were both, if we were both working for for an employer, and we said, I was saying to you, hey Angela, why don't we set up on our own? We can do what we're doing here on our own, so we can have Angela and Peter's buttery, and we can do much better than our employer. Because you and I are both butter professionals, we can do a brilliant job of
Yeah.
doing this. There's no stopping you doing that.
Yep, there's no
Um,
stopping us doing that as long as this is not something that we're trying to do with the employer and taking things from them.
yes,
Okay?
because
So we're not going to be walking
we're
away
not
with employers'
colluding, and we're
client
not
list or
colluding.
product supplier list and all that other shit, all the other
Yeah,
stuff that they have.
yeah,
Yeah, you
and we're
better
not
be on that.
colluding against the employer. Neither of us in that circumstances would be colluding against the employer.
Yeah, it has to be done in a proper way. Okay,
Yeah,
and you give your notice, and there has to be a working notice so that the employer could reasonably replace you.
yeah. The
Okay,
other question, okay, so you just mentioned something there, and that wasn't in. Is
there's
it in
wrongful resignation cases. Did you know
okay?
that?
Sorry, I was just going to say one thing about notice is that very often, and particularly in Canada and North America, I give you notice. Hey, Angela, I'm I'm saying goodbye. I'm giving you 2 weeks notice, and many employers will actually say, Angela then turns around and says, "Okay, Peter, just pick up your bag. I'm marching you out the door right now." You're
Mhm.
allowed to take anything like your mug, because I know you bought that in. That's a special mug you got from Quebec. You know, take that with you. Oh, you don't forget your cell phone and your cell phone charger, etc., etc. Hope you got a nice bag to put them in. You're taking them now, right? And because
Yeah, that's what some employers do. It's not
yeah,
always wise, but sometimes it is wise to do that,
yeah,
depending, because sometimes, especially if an employee leaves on bad terms or they give their resignation on bad
oh,
terms,
it's
you don't
not.
want them around. You
Yeah,
don't want them around
it's
because
not
they can start
necessarily
stealing
about
stuff.
it's not necessarily about bad terms. It's just about, let's, you've decided to leave. Let's end this now.
Yeah,
Boom, we're
yeah,
done. Right.
yeah. But
And
I've had a lot of workings with the nonprofit sector where they've still continued to work with us for 2 weeks
oh,
to a month,
yeah,
and then they left to go to the new position. But by that time, they were training their replacement, and then they left and went to
yeah.
wherever they were going.
Well, in fact, actually giving 2 weeks notice in many jobs wouldn't be enough to train your replacement,
Yeah,
because in fact your replacement's not going to come on for another 3 months, because it
yeah. And
typically.
there is some case law
Right.
about wrongful resignation that
Okay.
if you like if you work at a very specialized firm and you offer very specialized services and the firm is making money hand over fist from you, then you decide, that's it, I'm gone, goodbye employer, I'm gone tonight at 5 and that's it, take this job and shove it and pull a Johnny paycheck on it, right? And then you're walking out the door and the employer starts suffering financially as a result of your sudden resignation. They could go after you. Okay? So there's a balance, okay? Because an employer has to give you notice when they want you gone. And there's also balance in some cases that you have to give the employer reasonable notice.
Yeah. Okay. So we're discussing here this evening common myths of employment law. All right. And the next one we have on our list here is there is no such thing as just cause dismissal.
Oh, yes, there is. Okay. If you catch an employer stealing from you, or if somebody tries to pull a coup at your company, or if you have somebody who may have sexually assaulted somebody or has been charged with sexual harassment, or you've had different things where there has been evidence of cause. Like I had one guy who was dismissed because he went right into the cash of his employer and he stole money so that he can go home and buy a hit of cocaine. And they found him on security doing it. And the employer, yeah, he had just cause. These things you just can't do. I mean, just cause is when whatever you're doing, the actions irreparably destroy the relationship between the employer and the employee.
And so one example of that might well be that, hey, I bring my disk drive along, I plug it in and put it into my computer, and I'm starting typing away, copy these 1,000 files from the disk drive to my handy little device that I've got.
Mm-hmm.
Oh, by the way, you don't even know that it's there because it's in my jacket pocket.
Yeah, that's cause, because that's a form of theft.
Yeah. Yeah. So, but generally speaking, with the question about just cause, it's often not just one thing, like we were talking about data theft there, but it's actually a whole series of things.
Yeah, it doesn't have to be a specific thing, but it has to be something that is serious enough that just one incident of it could destroy the relationship between the employer and employee irrevocably.
I was also going to say there's another thing. I notice, Angela, that you take off. You've been with us 7 years now, and every time there's an Easter holiday, you take off Monday and Tuesday. And you know that in April that we are at our busiest, but every year you take this off as a family day off. This has got to stop, otherwise I'm going to write you up or give you a warning about this, because you know very well that you have to get permission for holiday, but you're always taking this day off sick.
Yeah, that's the same thing as the employee always takes Mondays off because like he always gets sick on Mondays. Interesting. Or sick on Fridays and they stay sick until Monday.
Yeah.
Okay, so those are always the interesting employees. Okay, that's when you start saying, okay, now we have to find out why you're sick. You need to go to the doctor, start getting doctor's notes, and you need to start doing things where you're starting to notice that this is a problem. That's not a just cause dismissal. That's a progressive disciplinary process.
Yeah. Oh, yeah.
Okay? Where you have to write them up, you talk to them, you do different things. They come in and show me, if there's something going on. There are some people that have to go to the doctors a lot for different appointments. They might develop a health condition where they have to get frequent treatments. But they have to provide that evidence. They have to be part of the accommodation process, okay, so that the employer can work around you, okay, if they could reasonably do so.
Yeah, and for example, there was a time when I remember way back in my past that I got injured while I was training for the London Marathon. And as part of my recovery from injury, I had to go once a week to a sports injury clinic and spent about 2.5 hours at the sports injury clinic, which meant I got into work about 11 o'clock on, but it was every Thursday.
Mm-hmm.
And the thing about this is that at a certain point, that employer said, you can't do that anymore.
Yep. Well, they're going to probably say, okay, we need to have some further documentation, okay, as to how long you need to do this. And if this is absolutely necessary that you have to do this on every Monday, or is that something you can move to after hours, or can be moved to Saturday? So there's different things that become part of the discussion.
Yeah. Yeah. Okay. So another one here. You can get fired for poor performance.
Absolutely. This is more of a segue from our previous discussion. Okay? But again, People are performing poorly, like particularly salespeople. They're always talking about how they have to have their sales numbers at a certain level, and they have to work up to that certain level, and then for a period of time to start maybe not reaching those certain levels. Is that a reason to fire them? Maybe not. Okay? There has to be an attempt on the part of the employer to help that person be able to recoup those numbers and to bring them up and to increase their performance. They call them performance improvement plans, or PIPs for short. They
And
put them
that's
in.
just to be clear, that's not poor performance, because hey, I come in this Monday and I'm so not feeling very well. I'm not ill, but I'm just not feeling good.
And that
And
happens to everybody. But if it's something becomes poor performance where it becomes more of a chronic thing,
yeah,
or this is for the last 6 weeks, you've been kind of going, whoop, things like that, you have to measure that and you have to work with the person. I'm noticing this. I've had to do this with a few people in my time, and I've had to ask them, is there something I can do? Is there something going on or something that I can do to assist? Okay.
yeah,
And generally, there is something going on in their lives. Like I found out one of them was just recently diagnosed with, I forget what it was, something that where she had to rest sometime during the daytime. Okay. So we just happened to have kind of a boardroom, but it had a couch in there. Right. So I said, if there's a time that you need to rest, you can take a half an hour, go in there and lay down. Right. If you feel that you need to. And it worked for her. Right? So her performance started to improve again. Right? But this is what you do. You have to try to look after these things, try to catch on to these things. And only after several communications, after several attempts to accommodate, after several things, then you can start moving towards writing them up, start having them, you know, in terms of suspension, firing, whatever, up to disciplinary procedures.
yeah. Okay, another one. The Employment Standards Act provides the statutory entitlements for employment, and that's all you're entitled to.
Oh, a lot of employers would love that
And
one.
notice if you look at this statement, I missed a word, and I missed it deliberately. The word I missed was minimum.
Yep,
People, pay attention. It is the minimum
yep,
standard.
yep.
You can negotiate more.
You can negotiate more, and also the Employment Standards Act is different than common law action. The Employment Standards Act may only give you 2 weeks, but if you sue for common law, you might get 8 weeks. So
Yeah.
these are various types of situations. And when I used to do this back in the 90s, when I used to work with employers and they had to fire someone, I would go with them and I would talk to them. And basically, we would offer them more than the minimum standard. So if the minimum standard is 2 weeks, we would offer them 8 weeks. But we would make them sign a release, okay, so that they cannot use that 8 weeks money to come after the employer and sue them. Okay,
Well,
so that they can just walk away.
you've just gotten on to the next item there, which is 1 month of severance pay per year of employment.
Yeah, that's another big thing. People used to think it was a rule of thumb. It's not necessarily. Actually, one of the things that I read, it was about 148 factors can play into what a severance entitlement might be for every case. Okay, so this is why I tell people it's very complicated when you're looking at employment law. There are very common factors that play into your severance. Okay, they're called Bardell factors, okay, which comes from the case against the Globe and Mail. Okay, and they talk about your age, the level of your employment, like are you a manager, are you a technician, your salary, the number of years you've been at the job, that sort of thing. These things are some of the key things.
So let's take one of those into consideration. You've been a year and a half at a job. Two people have been a year and a half at a job. One person's a manager, and one person is just just a normal clerk in the office. Now, what will come into play? You said salary. So the manager, even if you took the, hey, year and a half, so I'm going to give you 2 months worth of pay is your severance, right? What will come into play, of course, is the manager, let's say, gets twice as much as the clerk.
Mhm.
Therefore, their severance will be twice as much as the
Yeah,
clerk.
and also consider their age. You know, like the clerk may be only 32 years old and the manager might be 62.
Yeah.
Okay, so there's a lot of variations in these things, and they're based on this formula. So Bardell has been frequently quoted and went up. There's a lot of factors in addition to Bardell. There's Wallace. There's other places that have done this. There's Xerox and Shaw in terms of mannerism of constructive termination, like how a person is treated on the job. There's human rights damages. There's a lot of things that have to be considered when severance pay is concerned, and this is where you put your proposals forward to employers if you're going to be discussing severance pay. And included in severance pay is your bonuses or regular overtime. If your job involved overtime that you had to do, like say if you had to have 5 hours overtime on average every week, and then they give you your base salary and your severance. No, no, no. They've got to include the overtime. And then if part of your compensation was commissions, yes, they have to choose your average commissions as well. Right?
Yeah.
Because you have to have this as if you already had this. And there's
And
these things are all included.
especially when you're talking about salesmen, whereby a salesman might well be, and I'm just using this for argument's sake. So the salesman gets a base salary of $45,000, but they get a large commission on every sale they make. So typically the salesman is going to walk away with, say, 150, 160, 170, 200,000 a year on
Yep.
the salary. You can't pay them a termination based upon that 45,000.
Yep, you have to base them on the average with respect to the commissions as well. Okay, so if they're making 140, 150 to 170,000 a year, it's got to be based on that.
Yeah.
Okay, so it could be 2 months of that, could be 6 months of that, 12 months of that. Generally, there is an upper limit of 24 months in terms of severance, but we're starting to see more and more court cases where it exceeds 24 months. It's not common, but it's coming there. It's almost getting to a point where it's almost bad to employ people, like where employers might be discouraged from employing people with some of the laws that favor the employees.
Okay. So just to remind everybody, we're talking about some of the common myths of employment law here this evening on Spin Legal, and just wanted to kind of remind everybody of that and go on to our next issue. Absenteeism leads to termination for just cause.
Not for just cause, but absenteeism. The only thing that you would consider in terms of absenteeism if there's a job abandonment, and you consider the person who just goes home and never comes back to work and doesn't do anything, and you can't reach them, then they disappear. Okay? And that could be considered a job abandonment. But absenteeism, where somebody's just frequently absent, like miraculously every Friday and Monday, things like that, you have to check into it and follow through until you get to a point where if this isn't changing, that you could, then the employer has a decision to make.
Yeah. Okay. So next one we got on the list, we're on to the last couple, on to the home stretch now. I have no written contract, and so I have no rights.
Not true. People walk into employment. This is an unspoken contract. You have written contracts and you have an unspoken contract. The reason why people are having more and more written contracts is because of some of the things that the employer wants to have some more control over, such as termination pay. Okay? And even that's being challenged at the courts now, and the courts are starting to shoot down a lot of termination clauses. So you have to be very careful of how you construct those.
In fact, actually, you can come in, you can write, as part of taking the job in the first place, you can negotiate contracts, and part of that will be that you negotiate additional additional funds if you were terminated, particularly, as
Yep.
you said, if you were a higher ranking
Yep.
employee, like a chief executive officer.
I
That's
worked with
where,
a guy in the past where I was working with him, and he was a high level executive,
yeah,
and he was
that's,
terminated, and I helped him. I helped him add additional monies on his termination. And
and that's where many
they
of,
were going right by the contract that he
yeah,
had written when he came in, and it wasn't employment standards. It was just another type of thing that they put together. So I put in there because there were other things that were involved. He was working at one place. He was working at one place for a while, and then that company in particular just went over basically and lured him away from that job. And they brought him into the new company, and then he worked at that company, and then they terminated him.
yeah.
So
Well,
when
I was
that
going to say
happens, it's the time
the
spent at the old company and the new company add up, and that gives you your severance time.
the other one in relation to that is if you're writing your own contract, that may well be at the beginning of your employment term. That may well be when you write in golden parachutes.
Yep, exactly. And some of them would do that for you,
Yeah,
okay? Because there's a lot of companies, there's startups, and they really need you. If they don't have you, they're going to be very upset. Okay,
yeah,
so they will be more willing to put some stuff in there, particularly if you have high up or if you have very specific skills.
yeah,
Okay? But
absolutely.
having no contract means that you're protected under law and that you're all subject to common law and
Well,
ESA termination
and
clauses.
we talked about employment standards earlier on, and the fact that you've got no contract means that you actually do have a contract. You have a standard employment
Yeah,
contract.
exactly. It's both ESA and common law apply.
Yeah, yeah. Okay, so the last one on our list is year-to-year contracts means I have no rights. No right to notice, I mean.
Yeah, yeah, yep. You have the right to notice whether your contract goes every year to year or you just start off with a contract and you keep working there. Right? You have the same right to notice, period, in terms of termination or change of job or anything else.
Yep. Okay. So we've been talking here today about common myths of employment law, and I hope you've been enjoying that. And basically, if you want to contact either Angela or myself, you can do so at Invictus Legal by calling us at 905-688-5598, or you can email Angela at weareinvictus.legal, or me at peter@weareinvictus.legal, or go check out our website at weareinvictus.legal. Okay?
Yep.
And I'm going to leave this with Angela's favorite segue of the evening.
Yeah, what you heard today on Spin Legal is not legal advice. If you need legal advice, then please contact a paralegal or a lawyer. Because on this show, we cannot give specific legal advice to any listeners. Or even if you shoot a comment in our column and say, I have a situation like this, that does not constitute a retainer. You actually have to come in to the office and talk specifically about your situation, and then we have all the information available to even give you specific advice. Okay? But we hope that you would come in and speak to us. But anyways, just at least get legal advice from a paralegal or a lawyer.
Yeah. All right. And the other thing is that just as a point of interest, we're going to continue on the employment front next week. We're going to be talking about how to respond to your employer, how to respond when your employer fires you.
Yep. Fires you, lays you off, temporary lays you off. Hey, I got one case where there was a so-called temporary layoff. That was never communicated to my client, but they said, "Oh, it was a temporary layoff. Your client did not call the office back to come back to work. The employer never called the client back and said, 'Hey, the job's available now.'" Hey, there's a maximum. I think it's 13 weeks. I believe that you can be temporarily laid off before you start getting all
Well,
upset about
that's
termination
that's
and that.
that's an interesting one where people need to actually know what their rights are.
Yeah, exactly. And people don't. Okay?
Yeah.
And there's a federal workplace, a provincial workplace. There's a lot of different things that are there is differences, key nuances.
Yeah. Okay. Anything else really to say here?
Well, if people have any questions or comments they would like to share, just feel free to drop us a line either on the email address given or in our comment section or even on Facebook. Hey, I don't know if we're live streaming on Facebook yet. I hope we are.
We're not yet, no.
Not yet. Yeah, but at some point we
Next
will.
couple of weeks, we're hoping
Yeah,
to get there.
yeah, because it just looks like Facebook is punishing us for whatever.
Yeah.
Well, Peter's got to get rescued from Facebook jail. We're passing out the hat to pay for his bail. I
All
hope
right.
the food's good.
Well, okay. And we thank everybody for being with us. And I think we'll be seeing you again next week. And have a great evening.